That's it. And I've been cheating out. It is been I'll be the division. And 17. Very weak. Yes, Kanan. Right. And right. Yeah, right. Oh, standing. You were there. Yeah, you can do it. 6. Or Guardian, you're filing a repetitive date. And sir, you need to file any much time. I'm going to this. Okay. Direct concept representing is third. The actual deadline is 20 is is that's as right. And then file is file and context 19 of 19. As they are but right by the ECB president CB has been filed yesterday. But since I found it, any time model. Yes. In the subject, and then gets all 18. Yes, he does. Yes, something that
The petition, which was filed on 2nd of May, and till date the matter has not been listed yet.
Maybe lying defective.
Yes, sorry, Wesley.
Maybe lying defective.
No,
You
no
go and
matter.
inquire and make a mention.
That's okay.
file.
This is the bench 5 meter we are told, my lord, whether it is to
DRT division bench no is. First you find out whether it is a division bench matter or single bench. I think no, because Harrison so. History.
Right, my lord, I beg to mention.
less. He submitted an application. Can you sell? Okay. Final sale. And he submitted an application. Applications. First. Yeah. And it's all the brain position of it is what they have seen. That is why the application. And that not passed. What are not passed? Earlier, how many? How? Network is standing ready. Direction in cloud order created in color. I've not been by documentation after the created in color. They have submitted individual application along with something that then getting a period of 1 month of in color. The RS one where I say in a period of months as and have signing by passing a condition and the payment has been passed in respect to submitted by this Child election. Yes. Which is are busy there. How much time? 1 week. The 19th. Phase. Phase 9. I believe it come. But yes. And last. Extra task or something. Yes, same choices. Well. Second. Thanks. Yes. Snake. Well. I like it. Anytime. Yes, any instruction. No instruction. Yeah. 23rd. Same. Like it. Same thing. Same. at the end. That is a service kind of something about land. But it is mostly undeniably is of employees. Because employees are in a different category. They are educated, they are well, their intention to wait is quite intentional. We'll not spend money in litigation, let us wait. But so far as landowners are concerned, it is a different category. But I still want to know. It's very strict for you. Go against it. Find out more beneficial, it is a, for the landowner, it is beneficial. Otherwise, your case is taxable. Expressive fancy. So unless I get myself prime secretary, just for this, yes, that is why you have to make research for that. What's the good reason? After request for the start, it's after you. I a border and mutual and hearing that appeal. Spending spend. Yes. Yes. There is, I think, should not be issued direct. Response number 2 for early disposal of revenue appeal number so and so. Can you get instruction regarding pendency? That will expedite the issue. Or shall we dispose of? Why the revenue? Forget the revenue. Right. ARM. Registered. There is any
RM, VAT. ARM 509/2023.
Yes, 509 or 23. Later on, they have
Which one?
change it to that.
Which one is correct? RM. 1000. ARM. ARC. Green bracket. Cost paid payments, but earlier some information.
Now they have disposed the representation and admitted that yes, we have collected the excess amount, we have taken the money, but we shall not refund because the Hajj committee is a not-profit organization.
These petitions preferred earlier. The petition by some other. No, no, these two petitioners. There are two petitioners here.
Yes.
Anwarul Haq Loskar, Maktab Hussain Chaudhuri.
Yes, they do petition.
Whether they
both sides.
preferred any writ petition earlier.
This order is there. I have annexed, Lordship.
Please take me to that.
This page 41 is the operative portion of the order.
Maktab. This is one. Where is the other one?
Was collected as airfare for the chartered flight from the Guwahati to Jeddah. However, during the boarding at Guwahati embarkation, pilgrims of Assam were asked to take normal passenger flight instead of international chartered flight. It is the case of the petitioner that though the Hajj Committee of India had cancelled the chartered flight from the Guwahati, but excess amount which was deposited by the pilgrims for the chartered flight was not refunded. The petitioners accordingly submitted two representations addressed to the excess amount which was collected from the Hajj pilgrims, but the Hajj Committee as of date has not disposed the representation nor refunded the amount to the petitioners. Being aggrieved, the present petition has been filed with the limited prayer to direct the Hajj Committee of India to dispose the representation dated so and so submitted by the petitioner in accordance with the section 42 of the Hajj Committee Act 2002.
Section 14. Back. Also, again. It is depends on the is response number 3. He had disposed of. He had disposed of the represents. And by the What had happened to you? No, no, you deposited, okay.
Yeah.
What had happened to you?
And finally, they,
What
without,
had happened to you?
I have paid some extra money.
No, no, no. How did you go to Hajj? How? From Guwahati to? By Indigo flight? Huh? You purchased your own ticket? No, you purchased
No.
you deposited the money,
Yes,
right?
right.
You were thinking that I'll be taken in an international flight from air to directly
I was
to.
not thinking, it was confirmed accordingly, I have
1
paid for
minute.
that also.
So how did you go from Guwahati? Oh, other patients are also there. Relief states.
Whether it is chartered flight or single flight, the flight fare there is a difference, yes. Then they have the Hajj Committee of India, they have taken 1 lakh to 1,000 and tickets to the chartered flight.
What is your calculation? The efficacy is from the excess. Excess. You have calculated that 76,000 on account of chartered flight was taken.
I have calculated,
You don't calculate.
and this is a person there, $100, that is confirmed by the Indigo itself. They have given discount to the each and every
Hard.
pilgrims.
Mr. Z. Mazumdar. Doctor. Dining hall. Okay. Weather. Okay. Yeah, whatever. Is it reached somewhere? Where? It's bigger. And it is, that figure is here. Out of that you receive 543 lakh, something. Yeah. And the I think about disbursement of the amount. That is the big difference. There is only the disbursement cannot be done. Then you will have to keep that in bank guarantee then. Mr. J. Colital and Council for the. And each line. By the same. Right. Right. That's let me take that. And another sum of fees has been disbursed. In the petition in the meantime, meaning thereby it's some fees. So as it be disbursed out of the amount that's easy. I think it is the Right? Yes. As regards, status of its person remaining underneath. Underneath. The basis you claim. Because what you claim,
some exercise will be done all by the authorities, right?
Yes, sir.
Machinery will be, manpower will be involved.
Yes, sir.
So what is the basis of your claim? Kala will be involved, and district judge will be involved, everybody will be involved.
Yes, Lordship.
So what is the basis of your claim?
Lordship,
There has to be some basis.
I have no documentary evidence, Lordship, because I am not a landholder, Lordship.
Okay.
I am just a occupier, Lordship.
But what is the occupier? To claim as an occupier, what is the basis?
competent of the land. And the district judge will be involved. The seriousness of the claim, your claim is to be examined first. Take the basis. Your claim is ready. Louder. Read your agreement. Your first party. Your second party. And I, first party.
Middle, big betel nut tree, coconut tree, and two are numbers of water boarding. What we will receive from the Bharatmala Construction Authority will be divided into two-third shares, in which consented that the first party will receive 2 shares and second party 1 share. And after payment from Bharatmala, the second party promised to pay the first party. Because the Bharatmala Authority enroll my name in Jirat for the above mentioned betel nut tree, coconut tree, and two numbers of water boarding, and will credit the amount in the account of the second party. This is lordship up to that extent, lordship, it is right, lordship, but petitioner
You are
has-
involving High Court. After this agreement,
Yes, lordship.
you are involving High Court, competent authority and district judge. You have entered into your agreement fully.
Consent, keeping your eyes. Just what about nine. That you have entered into agreement. You received a compensation. The amount you bring credited in the bank account, as per number nine, thereafter will decide. So, so, apprehension, this is your agreement with you. We are not going there.
So that is your agreement, sir. I did not read it earlier.
Taken me,
I really did not. I thought that I'd be sending you to the district judge.
section 3. But you have entered into agreement yourself. You cannot do flip-flop. Go hot and cold at the same time. You agree with the
Response number 9, that you take all the money, thereafter we'll divide. And that agreement is before the district Kala.
you nicely done it. Some private agreement you have done.
And it is your agreement. Is it not? It is your agreement. You have brought it.
You have brought it on record. And it not been this document and some other document claiming your
Occupancy. I would have sent it to the district judge, and district judge will be involved. He will waste the judicial time.
I thought earlier. After making an agreement, you cannot
Not turn around. If there is dispute, you go to the civil court on the basis of this agreement. You have a claim there, but the right to receive the amount is with the response number 9.
as per your agreement. Is. And put up a witness. And you have read the content. Because it is clearly civil dispute up to now. You have abdicated your responsibility. And you have authorized the response number 9, received a compensation and the amount to be credited.
Bank account. Thereafter, the division of money will be made between you. So it is a case of civil dispute. Heard Mr. B. U. Oscar and counsel for the petitioner. You cannot invoke just for the sake of invoking the extraordinary jurisdiction.
Are NHAI and NHIDC. One. 7 and 8. And pending council revenue and disaster management department. Which and Mr. And measuring figures are covered by diagram 190 and measuring condition by final and increase. Any records. That's what. Five. And any number. Entering. What? Did not complain. Land complaint. What do you want? What do you want? Yeah, Jirat is gone. Jirat,
By agreement is gone.
minor agreement, Jirat is
Gone. Your Jirat claim is gone. I will hold so.
that is a statement of solution. On the basis of this agreement. Any kind of agreement exists. Prayer 1 and 2 and 3 gone. I'm holding. Just for the sake of it, you cannot
Involve all these parties. Right. You cannot, because after agreeing with this, you have to base your case in this agreement and claim the money from the respondent number 9 by virtue of a civil suit, not by this process.
Yes. It also claiming is
Is not also a patta holder.
number 6 paragraph. Of the state money. Like ANP entering into
An agreement to divide the proceeds after selling the Parliament House.
Lordship,
Huh?
Lordship,
It is looking like that now.
his name is recorded, Lordship.
Going deeper and deeper, both are dubious, it appears.
Read the description.
In position,
Yes,
or the
Lordship.
patta holder was civilian. Why you are entering into with him? Agreement with him, he is not in position.
Considering the future dispute, Lordship.
Huh? No. Para 9,
Yes, Lordship.
I was temporary possession. Order patta holder. Third, a scheduled land. Equation. Rather than petitioner. Scheduled land.
we are stopping the amount disbursement for both. public money cannot go through this drain. Neither he nor this man is the owner. And you are making the disbursement of 30 lakhs.
Yes, Mr. Roy, you stop this first. It will go back to the state only. Government of India might be spending money for the fund. Dubious persons living. Hired this, having the petitioner is living. Yeah. In the compensation amount assessed under section 3C. 1 of the National Highways Act in respect of the subject for chairman occupied and page 29, 54,326. But of the pleadings in the meeting the petition, it privacy emerges that neither the, of the communication dated 19,022. In bracket the next in the petition. It transfers that the same amount is contemplated that the same complex is worth the responsible line. From the statements and evidence made in this petition, privacy transfers that neither the petition nor the responsible line is the owner of the subject of inside of the matter, the his birth, that amount of the general assessed, assessed in favor of the respondent number 9 for the subject in the regarding.
Amount after re-verification, Lordship.
After re-verification, after
Ah.
25 লিখি দিব, 25.
25.
Alleged.
Hmm.
The so cause notice, order as well as the notification.
So cause notice on what basis?
On what is it does not disclose any reason. It is your lordship will see.
Summary so cause notice.
Yes, summary so cause notice.
Yes.
And your lordship will see at page 51. And it will be
This page 58 notice, notification is on the basis of 56, that 59 notice,
yes.
notification.
Yes, 58 notification on the basis of 59 and 59 is
Under consideration, legality.
yes, that's
Now it was Supreme Court case too.
SLP 424025.
That is there, my lord, but even though your lordship will see that after this 59,
I am passing an order in your favor.
And that SLP is scheduled to be listed again on 14th of May.
Okay. Let us see the legality and validity of that. Otherwise, on the summary so cause notice, the Korean bench has already
Yes.
held. It is under appeal?
And, yes, my lord, central government has gone under appeal.
That on the, no, on summary so cause. No, summary so cause is, all these cases are against you,
Yes, lord.
Yes.
not against central GST. Huh?
Construction category.
Right. That's
That is
not in
under-
appeal.
that is
Yes.
not-
So otherwise, if the legality and validity is held in favor of the central government,
Yes.
on page 59 notification, then everything goes.
Yes.
And if it is
Against.
held to be invalid, then petition will be
Yes, they will. be
favored.
written.
Yes.
So hard, Mr. O.P. Bhatti. Then counsel for the petitioner.
To be true. Understood. Finance and bracket taxes. Department. One. And it is a service. Cost. SC. And studying. SC. And studying. CGST. The petition in this petition has challenged a summary support with this issue under section 73(1) of the GST Act. GST Act 2017. And an order in origin passed. Dated 24. Passed on the basis of the same summary is under section 73, bracket 9 or 10. 9 or 10. 10. The NDST. The petition is also challenged. The notification dated 16/9/2020 and exactly issued by the finance in bracket next. Basis of challenge. The summary of the is required under sections of the NPST was never issued the petition and a summary is cannot be waited. It can issue the notice issued under section. That's the highlights of this. In addition, and 13. Is submitted that the notification dated 6/9 has been issued pursuant
56 stroke 2023, that's central tax, issued on 28/12/2023 by the central government in the Ministry of Finance in exercise of powers conferred under Section 168A of the Central Goods and Services Tax Act 2017, whereby the time limit for issuance of an order under Section 73 within bracket 9 of the CGST Act for recovery of tax, etc., has been extended for the financial year 2018-2019 up to 30/04/2024. Full stop. The legality and validity of the notification number 56/2023, that's central tax dated 28/12/2023, is under consideration of the Honorable Supreme Court of India in special leave to petition for special leave to appeal within bracket C number 4240/2025 within bracket Messrs HCC-SEW-MEIL so and so versus Commission of State Tax. Full stop. Para. Mr. Chaudhary, Learned Training Council Finance within bracket Taxation Department has submitted that the SLB is due to be listed on 14/5/2025. Full stop. Para. Issued notice returnable on so and so date as so and so has appeared, accepted notice on behalf of the so and so, formal notice is mentioned, extra copies within 2 working days from today. First of, having regard to the projection made that the petition has already been issued a summary show cause notice instead of a show cause notice under Section 73 within bracket 1, and the impugn order in original is passed on that basis, and the legality and validity of the notification number 56/2023, that's central tax dated 28/12/2023, is under consideration of the Honorable Supreme Court of India. It is Supreme Court, it is observed in the interim that there shall not be any coercive action against the petitioner on the basis of the impugned order in original dated so and so till the returnable date.
My lord, so far item number 18 is concerned. Only there are 2 matters. It
This is 24.
18 is also there, my lord.
18 is
Yes, similar matters, my lord. Only the so-called notice date is 3/09/2023.
show cause notice.
Dated 3/09,
Where is the page?
page 45, my lord.
Summary show cause notice, 30/09/2023.
And
To
the
order
order
in original
29/12/2023.
20/12/2023. Or
For the
notification 6/9
yes, same
Ah.
notification is same.
financial year. Okay. Financial year what? 2017-2018.
18.
Or this notification is based on which notification? There is another notification. A order also.
Yes.
Status completely notification.
Maybe
Lordship,
13 or 9.
Yes.
Perhaps 9.
9.
Itu 56 or 9 করে দিব 9 করে দিব. We have not annexed that.
That
It
notification.
will be, it must be 31/3/2023.
Yes.
Huh? 24 to year to over 2018-19. আর 18 হব financial year 2017 extended up to 31/12/2023. Alright, huh?
But
Or EP in order to same. Pass by.
Item 25. My lord, I was duly provided patta being patta number 14 by the Kabi Anglong.
Yes, madam, according to synopsis, you have refused to accept.
Should I be allowed to take instruction and
Better take instruction.
My lord,
private respondent also there?
No, the main grievance is that he preferred an appeal. That secretary, as the appellate authority, refused to accept the
my lord.
appeal.
Right?
Right? That is one of the ground of.
That is one of the ground.
If the appeal is entertained, then regarding the rights of the petitioner and the private respondent can be decided there.
My lord.
Why should we go in?
Instruction.
You better take instruction.
My lord, another thing is that it is actually it was done at the instance of respondent number 7, and now he is collecting the stone from my patta land, my lord. Still collecting. Nobody is restraining him, my lord. So
But your patta has been cancelled as far back as in the year 2021.
my lord.
But as on that, we cannot.
But no communication is made to me,
Right. That at the motion stage is difficult.
my lord.
After 4 years, you came to know.
My revenue is collecting till 25, my lord.
Right. But order of cancellation was in
that is there.
2021.
Yes, my
So
lord.
you have come after 3-4 years.
Nothing, no communication is made.
Right.
After RTI information, I came to
We'll
know.
examine Ms. Kemprai first. If the authority is the appellate authority,
My lord,
then he cannot refuse to accept
my
the
lord, my
appeal.
lord, my lord.
Heard Mr. D.C.C. Learned Counsel for the petitioner, and Ms. S. Kemprai, Learned Counsel representing Mr. J. Shutia. You are the standing counsel. Okay. Standing counsel. Then revenue, P.R. Mohanto, or revenue 1, S. Kemprai,
2 to 5.
standing counsel, Carbi Anglong Autonomous Council for the respondent number 2, 3, 4, 5.
Five.
Poster. The petitioner has stated that she was granted a Hiraz Patta for a plot of land measuring 30 bighas. Hiraz Patta number 14
14, my lord. Document number
for a plot
28.
of land measuring 30 bighas, covered by dag number 18, at village Borjuri Noke, Moja Duar Bamuni, Fuloni Revenue Circle, District, Karbi Anglong, subject plot. Post op. The petitioner has claimed that she has been paying the revenue in respect of the subject plot till date.
My lord,
Okay.
up to 25.
Post op. The petitioner has come to know
My lord,
that
my lord, document number is 28, my lord.
dag number 28 question. That the respondent authorities, without issuance of any notice and behind the back of the petitioner, cancelled the Khiraz Patta by an order dated 16/12/2021, and thereafter reallocated the Khiraz Patta for the subject land to the respondent number 6. Full stop. After getting the knowledge about the impugn order of cancellation dated 16/12/2021 through an application under the Right to Information Act, the petitioner opted to prefer an appeal before the respondent number
1. Two, my lord, it is.
2.
Secretary 3, my lord.
3.
Hmm.
As he is the appellate authority. Full stop. The grievance of the petitioner, one of the grievances of the petitioner is that despite preferring when the petitioner presented the appeal against the order of cancellation dated so and so before the respondent number 3 on 1/4/2025, the respondent number 3 refused to accept and acknowledge the receipt of the appeal. Full stop. The petitioner has stated that refusing to accept the appeal, the petitioner was advised by the respondent number 3 to approach this court by writ petition. If this kind of advice is given, then he has to come here. Right? Ms. Kemprai, standing counsel. AASC has sought for a week's time to obtain instruction as to the reason for non-acceptance of the appeal, stated to have been presented by the petitioner, by the respondent number 3. Full stop. As sought for by Ms. Kemprai, raised the case on 19/5. Mr. Fukon, learned counsel for the petitioner, shall furnish a copy of the writ petition along with annexer to Ms. Kemprai today,
No.
during the course of the day, in order to enable Ms. Kemprai to obtain the necessary instructions in this connection.
Oh, my lord.
Name of the learned standing counsel. Revenue Department be reflected in the respondent side, the cost list.
Lordship, can it be on 24?
24. We don't come on holidays.
Sorry, 23 Lordship.
23.
Okay.
26.
May please, lordship. The matter relates to our land demarcation, my lord.
Demarcation.
My lord, the petitioner is the joint partner of a plot of land within 4 acres, my lord.
You saw demarcation.
Demarcation, my lord.
How is your application? Where is your application?
My lord, page number 15 to 18, my lord. Annexure 3, page.
Authorities have gone digital now. Mr. Islam,
My lord,
authorities have gone digital now.
digital, my lord. I'm not make a direction to submit this. My lord. In so far, for me.
Heard Mr. B. Islam, learned counsel for the petition. A demarcation huh? And Mr. S.S. Roy, junior. Okay, revenue. Pierre Montor, revenue. You have notification, right? Demarcation. Is it available with you? Okay, land spending of revenue. Department for response number 1. Mr. S.S. Roy, Land Engineering Government Advocate Assam for response number 2 and 3. Full stop. The petition has stated that he is a joint partner in respect of a plot of land measuring 4 bighas, covered by DAG number 669 and KP pattern number 163, situated revenue village, Lochakona Gaon, Kisamot, Kamalpur Revenue Circle, District Kamrup, along with 2 other partners, post of seeking demarcation of his share of land measuring 1 bigha, 1 katha, 13 lessons. The petitioner stated to have submitted applications before the respondent number 3 on 12/3/2025 and before the respondent number before the respondent number 2 on 13/3/2025. Post of para vote Miss Mohanto and Miss Sir Roy have submitted comma in addition that you know fully well.
Sorry.
You know fully well
I-
what is to be done. I have seen your name in the order, similar order.
There should be one. Item 27.
May I please, Your Lordship? My lord, this is again land acquisition matter, my lord.
Not legalization, right to user.
Right to use that, my
Ah,
lord.
there is difference.
There is a difference, my lord.
You are
So-
still the owner.
Yes, I am the owner. correct.
If it is land acquisition, you are no longer owner.
Yes,
Hired Mr. J. Sharma, Landed Counsel for the petitioner. Any standing counsel?
standing counsel, my lord, for one.
Okay.
once-
Mr. Roy, you can accept the response. Okay. For the petitioner. Mr. S.S. Roy, Landed Central Government Counsel for the response number 1. And Miss M. Mormon, Landed Junior Government Advocate Assam for the response number 2
2 and 5. my lord.
and 5. Full stop. How much is the owner?
Total, my lord.
The petitioner has claimed that he is the landowner of 2 plots of land
2 plot of land.
measuring 1 bigha, 1 katha, covered by DAG number 296, FS Patta, Gran Patta, Para 2, and subject plot number 1, and 2 bighas, 10 lessons, covered by DAG number 375, FS Gran Patta number 1, at Panikhaiti Revenue Village, Peltala Moja, Kamrup Metro, District Kamrup Metro. First off, the petitioner was served 2 notices under Section 3 within bracket 1 of the Petroleum and Mineral Pipeline within bracket acquisition of a right of user in land bracket close, page 24 আছে, Act on a bracket close Act, 1962, whereby the petitioner was informed that the respondent number 3, no, 4, would acquire the right of user for the scheduled land mentioned therein. Notices. How many notices? 3.
3 notice, my lord.
Okay, notices, all dated 4/8/2020. No compensation.
No,
No.
assessment is not made.
Okay.
My lord.
The petitioner has stated that though the respondent authorities in the IZZL
Yes,
has acquired the right of user by taking
already laid down.
over the position
Yes,
of the scheduled land mentioned in the notices when as far back as in the year
2001 itself completed.
no 2001, this is 2000, this is notice, sir.
2020, notice was served in 2020, my lord.
Yeah. IZZL was not born in 2001.
2008, my lord. 18, as usual,
Ah,
born in 2018.
Yes.
Notice
You said
was served-
2001.
No, sorry, my lord. 2020. 2021, my lord, they have completed their job.
So when possession was taken over, that was laid down. Pipeline was laid down when?
21.
Okay, 2021. No compensation has been paid to the petitioner till date.
My lord.
Okay, issue notice returnable on so and so date. As so and so has appeared, accepted notice. Formal notice dispense to it. Extra copies within 2 working days. The petitioner shall take test for service of notice of the respondent number 3 and the respondent number 4 by registered post within 2 working days from
Right.
today.
Problem.
9/6.
I don't know, 28.
Yeah, please. Lord. What matters pertaining, my lord, compensation for my lord,
Electrocution.
yes, my lord.
Hey, electrocution code hai? Huh?
My.
No, electricity. 10183. It key. 10183. It missing level. Heard, Mr.
T shake, my lord.
T. Sheikh,
Right.
Land Council put a petition. Mr. Sheikh, this Assam State Electricity Board is there. Oh, then
APDC, now APDCL, my lord.
how we can, this is a non-existent entity. It has died.
First item.
It is dead now. Much prior to electrocution.
My lord, represented by my lord, Chief General Manager,
This cannot be.
APDCL, my,
This cannot be, sir.
my lord.
We are not going to rectify your mistake. The person died in 2023.
My
Right.
2020.
AACB died much before that.
My,
Person died in 2023. AACB died much before that.
APDCL has come, my lord. But I will be allowed to.
You file better
Correct.
particulars. No, will not do this. You file fresh.
Finish. My lord.
T. Sheikh And Mr.
B does not.
Pidas, standing
Pidas.
counsel.
Yes, ma'am.
APDC
Yes, ma'am.
Yes.
for adjustment number 2 and 3. Ms. M. Borman. Junior Government Advocate Assam for adjustment number 4 and 3 and 5. Full stop. As certain inadvertent errors have kept in the petition, Mr. Sheikh, Land Council for a petitioner, has submitted that the petitioner will withdraw this writ petition in order to file a press.
My lord.
Post op. The Liberty has agreed, Mr. So-and-so, or so-and-so has agreed to the submission of the Land Council for the petitioner. In view of the above submission made by Mr. Sheikh, Land Council for the petitioner, the petition is dismissed on withdrawal with the liberty to file a press.
I give rest, my lord.
29.
XCC আমার নাকি? This is bench 5. Okay, hard. Yes. Shall we dispose of? Notice. Hard, Mr. IA,
Yes, I am.
SI. Arkan Learning Council for the petitioner. Pierre Monto. And Standing Council, Revenue and Disaster Management Department for Respond number 1. Finance, Mr. R. Borpojail, and Standing Council Finance Department for Respond number 2. And Ms. M. Borman, and Junior Government Advocate Assam for Respond number 3, 4, and 5. First of all. The petitioner has stated that her mother, Onima Chowtal, sustained injuries in a road traffic accident on 4/2/2021 at a public place when she was knocked down from behind by an unknown offending vehicle. Full stop. Onima Chowtal succumbed to her injuries on 11/2/2021. Full stop. In connection with the accident, a police case, Bukakhat Police Station case number 124/2021 has been registered under sections 279/304, IPC. Full stop. Claiming ex gratia amount in terms of the notifications, dated 15/11/2014 and dated 31/10/2013, of the Revenue and Disaster Management Department, Government of Assam. The petitioners preferred the instant writ petition, stating that any representation,
Yes, lordship.
stating that
At page 24, 17/10/20.
the representation submitted by the petitioner earlier on
17/10/2023.
17/10/2023 before the respondent number 3 has not been given any consideration. Post of issue notice returnable in 4 weeks as so and so appeared, except extra copies within 2 working days.
Item 30.
May I please, your lordship? In your lordship, the petitioner seeking some information, file an application under RTI Act 01/2/2025.
Which
Your-
page?
Page 18, your lordship.
18.
18.
Before Director of Medical
Medical
Education, RTI.
RTI, your lordship. Then
Okay.
as it has not been considered within the stipulated period of 30 days, I preferred an appeal. There is an except 3 page 22. But it is an
Mr. Mojumdar,
inadvertent mistake on my part. The State Information Commission actually is the second appellate authority.
19.3,
Yes.
not 19. First you have to
It should be 19.1.
exhaust the remedy, first
Yes,
remedy.
yes. Now only question arises, your lordship, the limitation period is now gone. 30 days, 60 days. I file it on 1/2/2025. So your lordship, I humbly pray that it may be treated, I will make a necessary correction, it may be treated as
What is the limitation period?
30 days and 30 days.
19.1.
19.1, the RTI application
doesn't
should be
receive any
disposed of
fee,
within 30 days and another within
Under
30
section
days.
7 is agreed by the Union of
The 30 days, I have to make an application. So total 60 days, your lordship. But my RTI
Oh, no,
application
when it was first preferred,
on 1st February 2025. So
first
from-
February.
From there, from this 60 days, within 60 days, I have to file the first appeal.
Okay, who is the first appellate?
It is respondent number 1, your lordship.
Respondent number 1.
Number 1, Commissioner and Secretary, to the Governor of Medical Education and Research.
Yes, medical.
Yes, Medical and Research Department.
Yes, Mr. Cholia.
It is a bona fide mistake on my part, your Lordship.
Lordship, the claim of the petitioner has not been rejected yet, Lordship, and then.
So if within 1 month, he
Yes.
does not dispose of,
Lordship,
so he has the option of preferring an appeal.
Lordship,
He exercised
yes,
within time, but before a wrong forum,
yes,
Wrong.
Lordship,
right?
yes, Lord.
The forum should have been the respondent number 1,
Lordship,
right?
yes, Lord.
Now he is seeking a liberty
Yes.
that he should be given the liberty to prefer an appeal before the appellate authority. It is as per first appellate
First
authority,
appeal.
First of all, yes,
right? Respondent number 1.
Lordship,
But one hitch is that though he preferred the second appeal in time,
yes, Lordship,
but the time for preferring the first appeal has expired in the meantime.
yes, Lordship,
So he is saying that if my appeal is preferred before the respondent number 1, it should be treated as in time.
yes. No, no, so that,
Only the-
Otherwise, this man who is not furnishing the information, he will be called.
yes, Lordship may grant us that time, Lordship, yes, allow it. Lordship.
Let him file the appeal before
Yes,
the
yes,
respondent
Lordship,
number
yes, Lordship.
1. Then because at least he has the right and he approached maybe bona fide.
But before wrong forum.
It cannot be said that he has waited for 2-3 years. He's filed it. Heard, Mr. I am granting liberty to file an appeal before the respondent number 1. And since the petitioner has approached the second appellate authority instead of the first appellate
Yes,
authority, but in time, so
Yes.
his appeal should be treated as in time.
Yeah.
Lordship,
Much obliged.
Heard, Mr. R. Mojumdar, and counsel for the petitioner. Mr. H. Olial and standing counsel, Health and Family Welfare Department,
yes, Lordship.
for the respondent number 1.
1 and 3, Lord. He was,
Have you served a copy to the standing counsel?
Yes, yes.
No, State Information Commission.
Yes.
No,
yes.
is it, his name is available? Mr. D. Deca, right? You inform him, then
Yes.
we'll dispose of. You inform him, then we'll dispose of. D. Deca. Mr. Cholia, after some time,
Lordship.
let him be there.
Second up, your lordship.
As soon as he comes after the motion.
Item 31. Cancellation of registration.
Have you said that you have filed, you did not file any
My lord, I have read para 8, your lord.
para 8?
Para 6, page 6.
Para 6, page 6. Para 6, page 6. No,
regarding
this one. Give me something to leverage that. Come to page 29. This has reference to your reply. Did you file any reply?
my lord, that reply was filed, but
File.
that this is in reference to your reply dated in response to the notice dated so and so. It was done, my lord.
Did you file or not file?
But I inquired from my, that, but they are saying they don't have the copy of that. So I can't say, my lord, whether it is filed.
Because this is generated normally, we are finding it.
Whether it is filed, I inquired, my lord, but
Huh?
I didn't get any answer, my lord. From their record, it is not there. My lord.
Then there is no violation of nature justice.
My lord, in
See,
fact,
sir.
my lord, so,
His reply is also ABC.
Huh?
He has not stated clearly that whether he has filed.
my lord, regarding reply, my lord, I inquired, my lord, since, but in the reference it is there, but copy of that reply, they are also not aware whether it is filed or
How can it be?
they are saying, my lord, if
Okay. Did they appear?
no, my lord.
Give me otherwise this is 2022.
My lord, they may
You
consider
make a statement on affidavit. We are making it these two things, reply if not file, how can he say that reply was produced? If he did not appear, how can he say that I have heard you during personal
my lord,
hearing?
if my lord, they produce
They are
record,
also handicapped.
my lord, if
I
because
have asked Mr. Kyle time and again, but he could not because records are not maintained.
my lord, after all, my
It's
lord,
all online.
Everything is online.
my lord, if they produce it, my lord, because
You make a statement on affidavit, we'll dispose of.
my
Right?
Monday, my
No. We'll issue notice
My-
so that this is 2022, sir.
my lord,
Some kind of procedure is required to be maintained.
my lord, absolutely.
You sit in your house for 3 years, you come.
My lord, I agree, my lord.
All right, Mr. Egwell, Land Council for the petitioner, and Mr. S.C. Kyle, and Central Government Standing Council,
Yes.
CGST for all the aspects.
2, 3, 4.
Okay. Anybody? One, Miss P. Thakuria. B. Punjab.
Victory.
Bombay. Victory. Land Council representing PS Bhattacharya. Central Government Council for the Respondent 1. SC Kyle, Standing Council. CGST for the Respondent 2 to 4. First off, the petitioner has approached this court, agreed by cancellation of its registration under the CGST Act 2017 by an order dated 20/09/2022. First off, the petition was served with a show cause notice on 3/9/2022. First off, Mr. Well has submitted, the Council for the petition has submitted that the order of cancellation was reflects non-application on the mind of the proper officer, in that there was no reply submitted by the petitioner and the proper officer did not hold any public hearing yet, the proper officer had recorded that the reply of the petitioner was perused and submissions made at the time of personal hearing were considered, meaning thereby, the impugn order of cancellation registration suffers from non-application of my post of Mr. Goel has submitted that he will submit an affidavit with regard to the aforesaid two aspects. First of issue notice returnable for date 2nd of June
Not second, madam. Before second or after
Okay, 4th of June.
fourth.
Copies করে দিব। Mr. Gal, National Government Council shall also obtain instructions on the aforesaid two aspects as to whether any reply was submitted by the petitioner and any person in hearing was afforded to the petition.
Madam. Deeply.
Item 32.
RTI,
Lordship.
RTI. What?
Lordship, the fact of the case is that an RT application was presented seeking educational credentials of an employee who is holding public office. And while disposing the RTI application, citing the section 81J
Hmm.
of the RTI Act,
Hmm.
the authority refused to furnish the required information.
Hmm.
And thereafter, I have prepared first appeal
First
and
appeal.
second appeal.
First appeal before whom?
First appeal before the first appellate authority.
1 minute, which is furnishing information. Who is the impugn?
Yes, Lordship.
On bear reply, it is under the personal information can be exempted to disclose. Which an outsider, so and so, as there is no public interest shown accordingly. Okay. This is page 13.
Yes, page 13.
Then thereafter,
Then, Lordship, I have prepared in first appeal the
where?
copy of the appeal I have not annexed because it is not available, but a response from the authority is annexed and that's
Well, before the first appellate authority of this department.
then
Come to page 14.
yes, Lordship. May I read the page 14, Lordship?
Please.
With reference to the above, I am to inform you that as per the first RTI application dated 24/12/2024, the required information has already been furnished to you after observing all formalities under section 11 of the Act by this office letter so and so. On receipt of the said reply as furnished by this office and on being dissatisfied, you have preferred a first appeal dated so and so addressed to the District Public Information Officer, Office of the District Commissioner Kachar Silchar, who forwarded this to this office by this memo number not mentioned in the reference number 2. It is to be stated that if you have dissatisfied with the reply of the office letter dated 9/1/2025, then you could have filed or preferred first appeal before the departmental competent first appellate authority and instead DC office. Since you have submitted the first RTI application directly to the division, but not submitted to any other office and the same was not received on transfer under the section 6(3) of the Act. As such, you may file the first appeal before the first appellate authority of this department. Moreover, the undersigned does not empower this by the Act to forward your first appeal petition to the first appellate authority of the department, as there is no such provision available in the Act. However, the undersigned once again enclosing a copy of the order, copy of the letter dated 9/1/2025. So, Lordship, the first appellate authority, the appeal I have submitted before the Deputy District Commissioner, that was forwarded to them. So they could
To the PIO again. To the PIO.
Yes.
PIO again. And he has rightly observed. He has no power under section 6(3). You ought to have preferred before the first appellate authority. Right? Then without preferring an appeal now, you have preferred a second appeal before the second appellate authority. Now, you want a decision on procedure or on merit? On merit, I can dispose of the petition.
on procedure, Lordship. On procedure.
Right now,
Yes, procedure.
the type of information you are seeking
That's a procedure that I'll follow. And give the liberty to follow the
You
procedure.
file first thing. Otherwise, on merit, I am ready to dispose of this repetition.
On procedure, that's it.
You prefer them. I am not observing. Otherwise, if I go into it, what kind of information you are seeking, you are dead here right now.
On procedure,
You file your
the liberty may be given.
heard Mr. Absent Mojenwell and counsel for the petitioner. Why Central Information Commissioner? After hearing the land counsel for the petitioner at some length, Mr. Mojenwell and counsel for the petitioner has submitted that the petitioner would withdraw the writ petition in order to file a first appeal before the first appellate authority under section 19(1) of the Right to Information Act. So stop. In view of the above submission made by the land counsel for the petitioner, the writ petition is dismissed on withdrawal, reserving liberty to the petitioner to prefer a first appeal before the first appellate authority.
And one more line, if such appeal is preferred, then it shall be disposed.
I will not say much. I will not say much
It is mandatory.
until otherwise harassment of the authorities.
It is,
The kind of information you are seeking, this is
It is not corrected.
how can we?
Lordship, I have implemented them in person of this order.
in adjacent areas.
Subject to direction, the dark number and the pata number, I can really understand it's a large area.
Large area, I mean, 50 pixels.
Doesn't correlate. And
Hmm.
either as it may, there
Simple.
still might be proven.
Area. Yes.
We have,
But the entity is
yes.
one.
Entity is one, but for me to make a submission on behalf of my client, my lord, the retail cannot have a client submission in this. They reached out to the estate officer. They're very sure that it pertains to the IOC.
Status quo will be maintained.
Here reach, Guatikala, we told me.
Okay. এইটো এক নম্বৰ লাষ্টত লৈ লওঁ এক নম্বৰটো আছে ন লাষ্টত লৈ লওঁ ডিছপ'জ কৰি লওঁ পিছত
approached the appellate authority register, there was a stay order. Well, they approached the stay order before the appellate authority and sought time for 15 days. Then they came over before this court and this court provided a stay order. I filed an application for vacating of the stay order, but I find out, my lord, I have been, this issue has been covered by Biknupur judgment of your lordship. So on that basis, the repetition should be allowed and that impugn order has to be set aside because your lordship has held that in para, what I find, my lord, in para 72, that or summoning up, this court found that the register appointed under section 3 either or such and such.
It is in appeal perhaps.
Well, in the appeal, but my friend Talukdar has informed me yesterday, I talked to him, there is no
Yes,
stay
what
order.
has happened?
No stay order.
Huh.
So there is no stay order, so you'll.
Okay. এই মোবাইলটো আনকচোন
Will dispose of allowing their repetition.
right so that the it is there file কোনবাই থৈ দিছে it is always subject to reaching finality.
My lord,
Right.
here what I want to place in pursuance to my friend Mr. Talukdar's submission, 1992 3 SCC para page 1 para 10, description of stay and quashing is there. Stay until unless there is a stay. Writ petition comes up from the concept of, my lord, civil CPC 142 is there. I understand CPC is not fully applicable to writ petition, but the spirit comes. So if, my lord, filing of an appeal without a stay order does not give a stay proposition, then my lord, order 41 rule 5 would not have come. Here, if there is no stay order, the Bikrampuर judgment will follow. So their writ petition will be allowed. My lord.
No.
I'm asking you, law should be let down, my lord.
When something is submitted fairly,
Because but I cannot keep on, but I cannot keep on hanging, my lord. I cannot-
right, right. So that you can also be a party in support of your writ appeal. No, that there will be an opportunity for him. Whether he avails it or not, that is
because
a
it's
different
up to
issue.
him. It may be taken away from me also, my lord.
I'll not say you have considered. Oh, you are a petitioner there.
It's the petitioner.
That I'll find out. That's fine. And if you try on 10, you are calling provider. If you order dated 11, 12, 2000, comma, the responsible fee has admitted the debit referred by the responsible party under section 11 in bracket 1 class of operating by comma, comma, 7 and hostel and allowing one and only is a party only record is a party.
final. The responsible officer has also stated an order of the respondent number 4. Order dated 7. But whether whereby the respondent had allowed the time function as the secretary of assets. Ras Richard. I like it. The rest. As part of that, the interim order state remain in the disposal of the appeal. And so, when the other order.
So, this assistant register.
The other one I'm going to. Put it out to you. The other proposal. Apparently it is a delegated power. I'll observe. Yeah. So that. Kind of that power is delegated. Even one. It's has been delegated. And another question, 45(1)(11)(1). But this appears to be the view, so that observe so that the system can be streamlined. I've been seeing these kind of orders. Not.
What I'm trying to say is primarily, here the argument is that the case is covered by income. So therefore, my.
Okay.
Shipment disposal of on that line,
this particular issue may be kept open, so that I can also place the instruction and my lord, submit whatever my lord.
Fair enough. I'll leave it. I leave the question open. The what a petition, the petition, the petitions. ID number, comma, all our members.
Yeah, BOD, all are BOD,
Ah.
except 9. 9 is the secretary, newly appointed secretary.
Okay.
Okay, para 3, page 5.
Have approved. Stating that the petition number 1 to petition number 8 are directors in the board of Messrs. Raj Fisher Cooperative Society Limited. Second is the petitions have stated that they the petition number 1 the way got elected to the board of the society in the annual general meeting election held on 18/7 of 5-year meeting. The rest of was had approved the proceedings of the said AGM's election on 18/7/2020. 21/7. Response number 5. According to the petition, comma, the response number 5 was earlier appointed as the secretary of the society as the response number 5 had attained the age of 60 years, comma, the board's society was contemplating many like in order to pass a resolution to effect the board decided to hold a meeting of the board on 4/12/2020. However, prior to the meeting of the board scheduled of 2020, the respondent number the petition the respondent number 5 tendered his resignation from the post of secretary. However, when the meeting of the board was held on 4/12/2020, the board passed a resolution by resolution number 5. Permitting the service of the respondent of 5 as secretary of the society. When the said resolution, the board also decided that a petition number 9 is to be appointed as the secretary of the society. The board in the same meeting also resolved as the remuneration as the monthly salary be paid to the newly appointed secretary of the society. Please go back. So the regions are assigned in resolution number 5 for terminating the service. The by society. In view of the issue point involved in this petition, they abused necessity. Help into those regions. And what happened? Agreed by subsequent the board meeting and person and appointment and been issued in favor of the respective 9 on 5/12. At the head of the petition. One. That is, the chairman of the society. The response of when the proceedings of the board meeting held on 4/12/2000, were sent to the respondent number 4 for his approval. The respondent number 5. After consideration, why and this data get 7. Approved. The resolution of the board of the society by allowing the petition number 9 act as the secretary of the society. The responsible and further observe that the ex-secretary of the society, that is the responsible by should hand over the charge of the secretary to the petition number 9 for the greater interest of the same. The petition stated that pursuant to the appointment letter dated by the petition and joined the secretary of the society by submitting a joining letter on 7th of agreed by the appointment of the petition for 9 and 2nd and is removed from the post of secretary of the society. The responsible by prefer an appeal before the registrar of cooperative societies, Assam, under section 111 of the Act of 7. The appeal so filed by the 5 on 8/12/2020 came to be considered by the responsibility responsibility at their on 11 passed the imprint order SL the responsibility the imprint order has literally observed that although the board of directors of the cooperative society is empowered to appoint stroke remove a secretary as per the provisions of the 2007 Act. But the same has to be done following the provisions of
As part of the matter of removal or appointment of a secretary of a cooperative society was cooperative society of the society in the case in hand was the agenda fixed for the meeting of the board convened on 4/12/2024. Posto. The respondent number 3 has further observed that there is nothing on record to show that the respondent number 5, the earlier secretary of the society, was reported in the of being heard before the board of the society took the decision. The respondent number 3 observed by has admitted the appeal and posted the appeal for hearing on 18/5/2000. In the interim cover, the respondent number 3 has stated the order dated the approval granted by the respondent number 4 towards appointment in respect of the decision of the board of the society. Appointment of petition. That's it. In the best of the that's true. Yes, it all done. Planning. That's not that. Like, okay. Yes. That's it. In view of the enterprise. In the right. Others. Decided. Party. Of the other. It's true. That's the subject matter and one submitting that says the impact is pending and cancel consideration and just in an event till the till it is rendered in the
same. Right. Next, why should it come as submitted that both the submissions of Mr. Sinha and Mr. Kaluda cannot be right. This is both are correct. You are also agreeing to Mr. Talukdar that
Because,
wait for the outcome. So you leave it to me now
my lord.
so that carry to the it will not be taken. Para which para? In a judgment. Just part of submitted that. And in readable approach, cases have already been issued. Second. They start to and issue the time of the next then it comes for the part are not in basic agreement the point subject matter important retains remove of a secondary very big. Both Mr. Sena and Ms. as to whether the honor and benefit has asked any order in the pending investigation. They have answered in the negative. Meaning they have and it's making that only is accepting and stay with nothing. Staying there, yes, and then it is. That events and single events cannot ignore the ratio laid down in an earlier judgment merely because the issue is pending before a larger bench. Judicial propriety does not permit it to ignore the ratio laid down in the earlier judgment, as no decision regarding the same has come out from the larger bench. Full stop. Laid down in the High Courts have to protect decide matters on the basis of the law and its text. It is not open, unless specifically directed by a higher court, to event an outcome to an inference. As it is also not open to the high court and used by judgment by stating that it has been counted by later and The submission made by that's the next. For 12,000. When it was approved by the respondent number, the assistant register of cooperative societies. District Halagan. That. It perhaps appears that the see, the proceedings was approved by the corporate exercise of funds. Accordingly, under section 45. Seven. Delegated to him. Portion to him. If the under the act, powers government. Seven. The state from may by general hospital primary. But can tell you 20. Other. The base under the act. Which are other ways exercise by the rest. That is the if you know also privacy suffers from an infirmity in that that is so privacy appears to the that the approval accorded by the on 7,12,000 is an act of the registrar itself. In such view, the method the order. That the appellate record by the privacy appears to be under delegate privacy appears to be an order that is strength and such is the solution that appeal. The maintenance of the it appears to be in now be that as it may. Stop the situation is not decided and it is kept open for consideration in an appropriate. I think that will be. I've been seeing this kind of. Whether for your. So I have kept it open. I have kept it open. I have not decided. It is for you. As the issue. In no hearing is similar. The issue involving victim to crime society. Yes. And in view of the legal population. Expanded. This is to be decided. Yes. Found to be made of any minute. Consequently, very oh. I'm sorry. Is found merited. Consequently, the repetition stands allowed. The impugn order dated 11/12/2024 passed by the respondent number 3 is set aside and quashed. Yes, sir. Copy of the order passed today and connected with petition number 6. Nice. Application filed by the. I stands. Yes, Mr. Dick. Where is Mr. now? Held. You are not in the court. Okay. No, otherwise your issue is not involved. They prefer an appeal before you instead of approaching the first appellate authority. Now, in the meantime, the limitation period has expired. But since he prosecuted bona fidely first appeal, second appeal before you within time, so I thought that the better time should be that.
Section 14 of Litigation Act.
So in the spirit of section 14, and that he should be allowed to prefer an appeal before the respondent number 1, who is the first appellate authority, and appellate authority will decide. That is only. Heard Mr. R. Mozumdar. Let him come. Mr. A. Choliha, Lion Standing Council, Health and Family Welfare Department for the respondent number 1, 3,
4.
and 4. And Mr. D. Deka, Lion Standing Council, Assam State Information Commission for the respondent number 2. where Mr. The petition has approached this court, where he is in the petition. Agreed. Seeking earlier direction, the respondent number 2 and the respondent number 3 to furnish the information sought for by the petition in her application submitted under section 6 of the Right to Information Act. With the title 1. For the materials from record, it is noticed that seeking certain information, the petitioner submitted an application in section 6, the RTI Act, on 1/2/2025, before the respondent number, the public information officer, State Public Information Officer, SPIO, of the respondent number 3. Director of Medical Education, as within the prescribed time period, the information was not important, not for by the application dated. Was not furnished. The petition stated to have preferred a second appeal before the some state information. Madam, Mr. Ojunka, then counsel for the petition and respectively submitted that instead of preferring an appeal under section 19(3) of the RTI Act, correctly. And second appeal. Up to the first appeal under section 19(1). Yeah. Yes, also pointed out that growth pointed out that first step must be prepared in a period of 1 month or 30 days. 30 days. Sure. I'm okay. Sure. 1 month or 30 days. 30. From the date of appeal. First. But it of the expiry from the receipt. 30 days. A window of 30 days in case decision is given on the application by the SPI. It's and as part of us by section 19. an application can be admitted after the expiry of the minimum 30 days. If the first appellate authority suspended the applicant must be written by submitting this writing. And so either has submitted that other way. The appeal be heard, the second appeal. The something should pass within a period of 30 days. As it was sent on 17th of and so next month. Something submitted that. I don't think those things are even yet. And I can come up with that things. Cannot directly. Of the arguments. I think possible. It is that the respectable one is the first appellate authority. For presenting an appeal under 690 in case the petitioner has not received any information that SBI in connection with this. Right. The RBI and taxation and tax and direction to the responsible admit the appeal filed by the petition. As the petitioner has just the 30 minutes. Considering the fact that the petition presented the appeal within a period of 30 days, by as required under section 19 1 of the RTA in case of decision is given by the SBI. Albeit to the second appeal. This could not be the that the petition shall refer an appeal under section 19. One evidence. Therefore, dividing stands reserved to the petition. In a period, it is part of the by the petition. The respect of one shall consider such appeal in terms of the potential party. And the provider there to and in the spirit of section of the function of custom. Yes. Mercy. Payment of outstanding. And I think doing and doing. Yes, doing, yes. First one, and next one. So, if I may change by the petitioner. 50%. Custom. Stating it with the penalty was plus the imposed on the mass. Why the order and the page was 23 notes. Section 4. Paragraph 1, based on specific information. The officers of NT smuggling custom detected and recovered strings of friends from the Godam premises of business. On demand, on the Kumar Singh premises. The Godam premises of Sugam Parivahan was raided by the NT smuggling. So, and where was the last portion of the property and to pay 7%. Whether you have officer Lalunga or this was sent by registered post to Mr. Passing Messrs. It pays 27 lordship. That consignee will penalize. I impose penalty of 4 lakhs only on Robert Maswa under section 114 of the custom in 1962.
Which
For-
paragraph?
8 page 27 last paragraph. Respondent authority.
Who is the customs?
Except I. The notice which I made, demand notice issued by the respondent. Can I accept? Except I page 37. Subject demand notice plus the penalty. Since a plus the penalty. Also imposed upon, that is imposed on Anukumar Singh.
Hmm.
But subsequently in the year 2018, Lordship, they issued the notice to the petitioner.
Which one?
That is imping before you in this petition.
Which
That
one?
is annexure 1, page 90. Yes, that imposed on the Anukumar Singh.
Hmm. The previous one. The previous, you were asked the price. Regarding Anukumar Singh. Anukumar Singh has left the company. As a When?
petitioner
When?
in the year 2017. Let me retire. You're supposed to take today. Thank you. In the case of distributors. LPG or what? LPG. They are existing LPG operators, my lord. Jadhav Pora, my lord, Jadhav Pora is the respondent, private respondent, I think 36.
Blue, first 36. Blooming.
My lord. 5312, there Jadhav Pora, your lordship has just gotten a order.
Jadhav Bora.
Yes, he is respond number 5. Respond number
Five.
5. He has been allotted. He has been commissioned with the outlet. He is blooming. Right. Then it's never
Otherwise, your reputation has become infructuous. He was appointed as far back as in the year 2020.
My lord, that's why we try to establish contact.
You get this forward into your client. If you want to challenge after 5 years, you are operating
my lord.
LPG distributor, you are fully aware who is operating now since 5 years
Right.
near you. If you are not challenging it, if the person is not contacting you, I think he is happy with the situation.
My lord, we tried to, but then
No, this has become infructuous.
And
Yes, my
item
lord.
number 37, my lord. There two public notices were challenged where many rural offices.
37, 37.
introduced. In that regard, my lord, the email trail that is before your lordship,
Email trail.
the first.
1 minute.
Yes, my lord.
Email trail next to his, next to you. Email trail, yes.
Itu আমার, no? Itu আমি।
Reading,
No, your lordship.
right? Allotment of LPG distributorship pursuant to the aforesaid process would be subject to the outcome of the writ petition. That was the order in 2018, right? 13 July 2018. 7 years have almost passed, almost.
Case was heard last upon instructions of this honorable court.
An item was delivered.
Our item was delivered, your lordship. Your lordship may find the track
Ah.
consignment pages. The two consignments addressed. They're delivered on 5th of May.
When I say change. Unified guideline of which one?
Public notice.
Lordship, two of them.
47, my lord, page 46.
46.
Page 46.
Okay, this has been acted upon, I'll say, by appointment of a new
LPG distributors. In your writ petition, page 46.
Indeed, lordship.
This was under challenge.
This was under challenge.
This has been acted upon,
Indeed.
and LPG distributors have been appointed, right? In most of the locations already. So there is a fresh cause of action which are required to be challenged.
Indeed.
So such a challenge is not made in this writ petition. this repetition is closed. Liberty is, however, available to you to challenge those appointment orders. I think
As your
that will
lordship,
meet the situation.
as your lordship pleases.
So that has been acted upon and new distributors have been appointed on most of the locations. So that has to be challenged. Since no stay is there ultimately for 7 years. Heard Mr.
As Ram and comfort of petition. And Mr. Nelson, right? One. One. The petitioner A. And challenge. And appellate. Whereby application being made. Appointment. Selection and appointment. LPG distributors. In a number of locations. And Raja, my just short. Direct. That's something that. The respondent number 5, Maheri, had already been issued a letter of intent on 3/10/2018. And subsequent the five has been appointed as the LPG distributor. At the subject location of Raja Mile. As the letter of intent by dated 2018 has not been challenged in this petition. And for a period of 5 years by the petition for above period of time. And the letter and other new inspection. That's it. I will regard to the nature of the and considering the fact that the electro meter was time that's in 2018. And thereafter, distributorship was appointed as a distributor for the subject location at Raza Maya 31/10/2020 by the respondent ILC Limited. On this has coming back to the petition is our delivered challenge. The letter of intent dated in the appointment of the as distributed and subject to government in an have a copy. Copy. The appointment letter. Perfect. Appointment of and various well areas across the state of yes. Perfect. And 27. Finance. And the registered practice. It's part of track consignment. Track consignment. Distributors. And most of the issues. Advertised. In a notice dated 12/6. have already been appointed. And it is those letter of appointments, LOAs, are to be challenged and approved as issuance of determinants that price increase. Price based on the price. For the petitioner. Yes. As the account. Now, it's payers. And considering the fact that distributors have been appointed and most of the sub patients advertised for appointment of distributors when giving rise to this. Image. Is good for them. Purpose of this law to proceed further with this. It is for the petitioners. Say. The distributors. Subsequent. And you want to challenge it? Right. Yes, thanks. Thank you.
It 3 weeks time to file affidavit. One more. 5 years gone by. Okay. Good ground. Mr.
R. Besbura.
R.
Besbura.
Bezbura.
on
For
behalf
the
of M7.
petitioner, Miss Boro, Bora, Miss R. B. Bora, Standing Council BTC for the respondent number 1, 2.
Stand us. Three. And Mr. BK Singh. Then council for the rest of 5 minutes. Mr. Singh. Recently, thousand then council for the rest of 5 minutes. Just further, wait for further. Field stay to file the affidavit of behalf of state. The phrase in the Okay. According to hearing that the
Mr. O.P. Bhati, Learning Counsel for the petitioners, and Mr. I. Bhattakur, Learning Standing Counsel, Excise Department for the respondents, state respondents. Full stop.
yes, the decision. And if you say that does not cover and things. Submission. Yes, the cases. That's what we're going. Yes, the cases. It's okay. Oh. Is this cover? Close. In favor or against?
I don't know, I have not seen
It is against me.
against the petition. Okay. This is WBC number 1203.
Yes.
Okay. Hey, তাদের নামটো আছে কিবা পার্টির নামটো Mr. Heard Mr. O.P. Bhati, Learned Counsel for the petition, and Mr. I. Bhattakur, Learned Standing Counsel. It cases নহব তেনেহলে
Yes, recognition is really covered by the decision in say which one then? Give me. Dynasty bonded to her house.
Yes.
Okay.
The judgment. Dated 20. In Dynasty. Yes, I am not reading it. There is no paragraph 25 here.
Sorry. Oh. Yes, my lord, para 8.
demand is there. Which one? Not read any
Lord, I'm relying upon you.
up to this. Is fairly covered. What observing? Okay. So I cannot go to a paradigm directly. Not directly. There is no demand on it. What is the USL? As both of you have
Not read the brief. I have also not read the brief.
My,
What they have done, my lord, they have mentioned establishment charge that they do not want to pay, but they have not annexed it.
The squarely covered, I what have also says. So in what last line, what should be recorded? That is why I'm asking. You have said
My-
squarely covered.
my lord,
What have you said squarely covered?
your lordship may.
So what
say-
is the last line to be recorded?
Your lordship may say that if it is liable to pay, in
Huh?
accordance, liable to pay the establishment charges in accordance with the judgment of this.
Now, what this judgment has done, it has asked the authorities.
Whatever direct
So the standing counsel, excise department has also endorsed the submission that the case is squarely covered by the decision in so and so custom. In view of such consensus, in view of such submission made by the learned counsel for the parties, this writ petition stands disposed of with an observation that if upon due verification and consideration of the documents placed by the petitioner side, comma,
establishment charge is found due. The excise department will sell the competition accordingly and thereafter. The petition. Put it such a. And the petition fails to be run into incomes. Run into. Then the respondent is immediately ready. With the process of realization. Like what it should. The stand. I did this. That's. It's. Yes, the last. Under 101. I see. That's okay. And cancel. Then you challenge it. Yes, sir. Then they are still to file their reply. Right? They are still to file their reply. File the reply. PK Garodial and.
The petitioner.
Mr. M. Yeah, I am standing. I consider presenting. The. With the sending of the. Big Google and sending.
Health and Family Welfare Department for all the respondents. Full stop. Mr. Bhuiyan has submitted that instructions have been received to file the counter affidavit on behalf of the respondents and has sought for how much time? Okay, so sought for listing of the case after 2 weeks in order to file a counter affidavit. First off, the appraisal or list the case after 2 weeks. The status quo or the past earlier shall continue till the next date of listing.
Item 42.
Like that. That's it. So being aware.
So that.
Allotment was made prior to construction.
They have made some arrangement with that point of time with the head of the chairman. Against that illegal allotment, police case has already been registered.
What was the interim order passed?
Status quo.
So you are in position.
Validity of the cancellation order.
It's not to be not through a due process. It may become
Vulnerable also, the original allotment.
No opportunity of hearing was given prior to the cancellation or passing of the cancellation order. At least I should be heard like.
That for examining that question, we will also examine whether any due process was followed.
paid accounting. Not paid. Keep it.
Permit officer otherwise.
Executive. Right. Hostile. But it's the issue, I think. Is that
And the affairs also,
Yes, and
Yes.
budget time.
because there is nobody, no board.
Yeah.
So till that time you run the management also.
Yeah.
Board of management.
Election has been.
But
held.
you run the affairs also.
Election has been held.
The name is officer on management.
Might not have been satisfied.
Only, the court had only directed that Mr. S.K. Talukdar's name to be reflected in the cause list. There was no other direction.
So whatever he has said just now, is it there on record?
Yes, Lordship, it is already there on record.
So Mr. Talwar will be there, then we post it on some other day for hearing.
I didn't agree. Yes. Yeah. That's, yeah. Why? Right. Yeah. That's. As a person. Okay. One, all the Is that it? And then five. Is good. Is good. Fantastic. A good name. And I'm reducing my work. I'm at the, so that my, they also when the matter is gone. None has appeared for the condition. Few of such repeated on presentation. But few of such. So, five, six, seven, eight. Extra. And nine. That's the. That. The. Same time. Another penny. Definitive. After. Fine. Yes. Addition. Yes. After. Now calculate something else. Fully available. Alcohol direct. Mr. Yale. I think one step ahead. Mr. TW. Direct cost. That's top. Second. That's cost. Next. AMS call. Acquisition property.
Please, it was a proceed before the arbitrator,
Lordship.
appointed in respect to acquisition process.
Yes.
Okay. Belonging to. I have not understood from the order.
Lordship.
Yes. What is your case?
Case is not Lordship. The
Your land has been acquired.
acquired,
Under what?
Lordship, National Highway Lordship.
Highway Act.
Lord.
Then
Then-
award was passed.
Lordship, some money was offered, Lordship. Then petitioner appeared before, approached before.
Some money,
Full court.
award was
Yes.
passed.
No,
Award was passed.
no order was passed, Lordship. Award was passed, Lordship. Petitioner approached this honorable court. Honorable court, Lordship, by this order, Lordship, page 81, Lordship. There, page 81, Lordship. The file, the directed, Lordship, page 83, Lordship, paragraph 5, Lordship. The 11 portion.
Competent authority.
File and directed the petitioner to file an application, Lordship, and directed the competent authority to refer.
Inadequacy compensation, 3G5,
Yes, 3G5.
refer to the arbitrator.
Arbitrator.
Huh.
Then accordingly, petitioner submitted. Matter was referred to the arbitrator. And Lordship, the process of arbitration start, Lordship. The matter was not finalized, Lordship, by the arbitrator, Lordship. That is the response.
There is some difficulty many times.
Yes, Lordship.
Because arbitrator was abolished, all this.
Lordship. But
Then what happened?
before Lordship.
Now presently before arbitrator or not?
Maybe arbitrator.
Then-
Before determining the Lordship, the amount, Lordship, compensation amount, the authority tried to abolish the instructions and take the possession, Lordship. Then I have filed this application.
In the one is passed. Compensation amount is fixed. Right? Now you are paid by inadequacy. Then why you have prepared
This and what is the observation? Please,
Lordship,
Mr. Mojumdar, don't put the clock back.
no, Lordship.
Please come to, or then you should have preferred an appeal.
No, Lordship.
Come to page 86.
That is, award is an offer only.
No documentary, nothing was there, Lordship.
No, then you should have preferred then.
Then Lordship, I have.
The under, this was, please,
Lordship.
please read now.
Page 86. Something was quoted. Disposal of repetition. There was earlier repetition perhaps.
Yes, Lord.
This court, having taken note of the provisions of 1956,
Yes, Lord.
is of the opinion that if the petitioner is aggrieved
With the
with the
inadequacy.
inadequacy of the compensation, the petitioner has the option of approaching the competent authority,
Yes, Lord.
seeking a reference to the arbitrator in terms of section 3(z)(5) of the Act.
Lordship.
Further to that, once the determination has already been done by the competent authority, the same can only be modified or interfered with except in terms of section 3(z)(5).
Yes.
It is clearly recorded,
Lordship.
right? So compensation means the award. Now you cannot put the clock back.
No, Lord.
Don't put the clock back.
Lordship.
You have to go forward.
Forward, Lord.
Now 3(z)(5), it has been observed.
Yes.
So the matter is before
the arbitrator.
arbitrator.
Lordship.
Now for what purpose
Lordship.
this writ petition is?
Because before determining the award, Lordship, as per 3G, under section 3G, they are trying to, Lordship, demolish the Lordship. Last Lordship,
Then I will issue mandamus to demolish,
Lordship 3H, Lordship, kindly.
not 3H.
Says done. Please be one. Determined under section
3(1) shall be deposited by the such manner as been laid down in a rules made in this behalf by that government with the competent authority before taking over possession of land. Let us see the rules.
Recommended an expert in arbitration. Amendments. I am actually not in conference. There is some maintained. Find out Mr.
Majumdar, so not Majumdar, the other Majumdar.
PG comes after stage of 3M. 3D and 3M. In 3D, 3E, power to take position. And 3M, right to enter. Right. So they have the right to enter.
Right to,
And to do acts, other acts necessary after the line for carrying out the building, maintenance, management or operation of a national highway or part thereof.
or any other work connected therewith.
And there is another. Is that the use of cancellation? There is another. Your case is not that my legal land has been acquired. And I have been paid million for only one. Not your case. It is your case is inadequacy of compensation. So it will be based on zonal valuation and etc., nearby land, sale deed, existing sale deed, all these. Why you are stopping a national highway?
No, I'm not stopping lordship. I want lordship, they may determine lordship.
Easy used to be, I think it used to be interpreted that 3 in 3H1 is to be interpreted as 3G within bracket 1, not 3G within bracket 5 and 3G within bracket 7.
Ah. Will enjoy. So he is not satisfied that number. First thing. Put his money in everyday fruits. Get the answer. Yeah, straight.
He is from Punjab and Haryana. I got him move that case.
Landed council for application. And beach already, standing council. Finance and Taxation Department for the response number 2 and 3.
Yes, item number one, I put that, uh, I thought of- Yes. Why it just come forward? Yes. I think it.
Directly, which they cannot do indirectly. Your Lordship, we are in possession of the
1
house
minute. Let
and
me see.
they have not gone to the civil court, Your Lordship. They have come here with to allow them to construct the deliberate to make some repairs in the house. Well, we are the owner of the house.
1, 2, 3, 4. Who is for the 4?
4 is there appearing here.
And who is for response number 3?
Pick up.
No.
Tejpur Municipal Board, Your Lordship.
Who is representing response number 3?
There, council, right?
Advocate.
Affidavit of response number 3 is filed.
So affidavit in opposition is also filed by the response number 4.
Yes, Your Lordship.
And thereafter, this IA has been filed.
Yes,
Right?
yes.
Do you intend to file any affidavit in reply?
No, Your Lordship, since.
Not I am yes or no?
No, sir.
No. So pleading is complete
Pleading is complete.
in the main writ petition.
Why should we bother with IA? Can pick up the petition itself. Is it not? Yes, madam, why you
Want vacation?
like this IA will
Dismissal of the writ petition.
In fact, they are trying to.
Mr. Pusilal.
affidavit in reply. The affidavit in position filed by the she and the husband of public. Yes. That's. Okay. Yes. Maintain or maintain. We are not taking that. We have also a calendar. Yes, Mr. Tiwari, you are waiting, what?
No urgency on my part. I am for the respondent only. But I think urgency may be on his part. I don't know.
Which one?
Item 56, sir. I appear for respondent Oil India.
Okay.
I am appearing as petitioner in person.
Okay, we'll put it on next Friday then.
Expired, sir.
We fix only after a stage is passed. After consideration, we fix on those cases. Since we are not applied my mind, so on Friday. Mr. Tamuli, you are Tamuli?
No, sir. Petitioner in person, Udipta Mess.
Okay. The petitioning person and Mr. P.K. Tiwari learned senior counsel stated by Mr. K. Korita for the response number. All the responses are present. First up, as thought for as agreed to by the learned counsel for the parties, list the case on 21.
Yes. Some legally also. Which one I can? Mr. Swami. 59. Mr. Ashwaman. Sector name of Mr. B. Gogoi, Learned Planning Council. Ah. Okay. Additional Advocate General in the respondent side, the cause list.
My lord,
Simple
item
order.
55, my lord, interim order is there, lord. That may be continued.
55. Which in the board. No, the prayer of Mr. And then board being. And the ordered if it's expected of the law. Yeah, many things. And that reference to ordered if it's expected. One. That is reference. Yes, like you have many corrections. Same order.